going to recognize myself for a few minutes to talk with you gentlemen. Regarding detainers, please just clarify for America, and keep in mind that this is a roundtable discussion. It's rather informal as compared to a hearing. But what we're doing is part of the historical record. It's being live streamed, and every word you're saying been documented for our country, so people have opportunity to hear your message, even if they're not in the room. Regarding detainers, please clarify for America that if you have a man in custody in jail, like Sergeant Zalapone, if you have a warrant on your shift for someone that's in jail one county over from Butler, and you know he's incarcerated there, then that detainer is placed with that jail. And won't they notify your department when they're ready to release that guy so you can go pick him up?
Yes, Congressman.
That happens all the time, am I right?
It should.
Across the country. Sergeant Lenz?
Yes.
You Colonel?
Yes, sir, at all levels.
Okay, at all levels. What we want to clarify for America is that detainers work very well across the country, in every county, in every state, for every department. The exception here as being described, but as part of the national narrative right now, is recognizing a detainer for ICE. It's where you have some communities, some municipalities, some counties, some cities. They are not honoring detainers for ICE. It means ICE has a warrant for this guy, but they're not arranging for a safe transition of the incarceration of that human being from wherever he is currently incarcerated into ICE's custody. They're doing it for the county next door and the city down in another part of the state, but they're not doing it for ICE. And this does present a danger to the entire community. So, you gentlemen, do you see in the course of your profession, you've been behind a badge for many years, cumulatively, I don't know how much, probably 50, 60 years easily of service here. Wouldn't it be unsafe for the community, for any jurisdictional authority to not recognize the existing warrant of someone to have in custody, Colonel? Wouldn't that be a danger to the community?
Yes, sir. It's a danger to everyone in the community. When someone is fleeing from a jail, a prison, whether it's a state or federal facility, they're fleeing because they know there's an outstanding warrant.
Bad things
or
can
detainer.
happen.
Yeah, and they will do whatever it takes not to go back to that facility. And it doesn't matter, man, woman, black, white, it does not matter. They just want to remain free and unincarcerated, even though they have to be held accountable for crimes they've committed.
Yes, sir. Sergeant Lynn, should we be honoring detainers and active warrants or not?
Yes, if we already have somebody in custody, generally speaking, it is safe for us to transfer them to somebody else's custody.
So if they contact you, you have them in your county jail, and in the next county over or a county across the state has a warrant for that person, will you hold them for a reasonable amount of time?
Absolutely.
And Sergeant Zalapone, do you agree?
Yes, sir.
Okay, that's unanimous. Regarding drone actions, Colonel Hodges, will you describe for my colleagues and for the Americans watching what has happened with our effort in Louisiana to purchase and be certified on and deploy drone mitigation, criminal drone mitigation technology that allows law enforcement using the standards of probable cause to mitigate, to track, to identify and track a criminal drone. And if it's identified as a threat, within the parameters of training and probable cause, and to take control of that drone and force it to land. So the controlling of that drone and forcing it to land is in my considered opinion, a law enforcement action. And yet, states are being stifled from using that technology as a law enforcement action based upon a wrong interpretation of existing laws. Essentially, Colonel, will you briefly summarize that, please, so my colleagues will know where we are?
So, as many of you all know, New Orleans, Louisiana hosted a Super Bowl, followed by a Mardi Gras earlier this year. Both events were Tier 1 rated, which allowed for the TFR, a temporary flight restriction, in and around those areas, both the NFL experience for the Super Bowl as well as the Caesars Superdome and other areas where NFL events were taking place. And then it extended through Mardi Gras in New Orleans. Although the capability and the training, our troopers have that, we do not have authorization to mitigate a drone, which is to take down a drone that puts the public at risk, as the chairman pointed out, with probable cause, and obviously, within the laws to do so, we have to have the assistance of the Coast Guard, the Secret Service, the FBI, or Department of Homeland Security, the way it stands right now. So although as a state police agency, we have the same training, the same capability, the same equipment, and we work with them, they presently, only federal law enforcement has the authorization to mitigate a drone, and that happened throughout the Super Bowl and through Mardi Gras for public safety purposes. Everyone knows on January 1st, we had a terrorist attack in New Orleans, and it was a heightened level of security. We had DHS Secretary Kristi Noem visit, as well as our U.S. Attorney Pam Bondi visit the city that week of Super Bowl and understood those concerns. And we hope that you all, as Congress, can give some provide authorization to states, and specifically include Louisiana. Certainly, we want to have the training, which we have, and there should be requirements and things in place, but we have to have that today. The drone is such an important tool, and Congressman Higgins has been an incredible supporter of this project, and more importantly, this initiative. As law enforcement expands and technology moves forward, we realize that drones won't replace our aircraft, our helicopters and planes, but they are a quick deployable law enforcement resource. And long-range drones require a waiver to use a military signal, which Congressman Higgins was able to help us with. But specifically to the mitigation, presently, the way the interpretation of the law by those here in Washington is that states do not have the authority to mitigate a drone, even though Louisiana has argued differently.
So if I could interject, gentlemen, and Ms. Bober, think about that. What they're saying is that I believe is a wrongful interpretation of existing law. They're saying that law enforcement, state law enforcement, Louisiana State Police, has a technology, existing technology, commercially available, that can track a criminal drone, and if law enforcement have line of sight on that criminal drone, and they have the technology to take control of that drone, but the existing interpretation of the law says that they don't have the authority to do that. They have to have special permission. And we ask them why. They say, well, it's a violation of a law interfering with a radio signal. We say, wait, it's a violation of the law to shoot someone. But the police officers with probable cause have the right to use lethal force. It's a violation of the law to crash your car into someone's car. Well, police officers have been using a pit maneuver to move, criminal cars that are running, been using pit maneuver for decades. So those actions are not violations of existing law. They are law enforcement actions. So when you pit a car, that's not a car crash. It's not investigated by Louisiana State Police with a Louisiana Uniform Motor Vehicle Crash Report. It becomes part of the narrative of the criminal investigation that you crashed that car. That's where you take down the details of the car that you pitted, serial number, et cetera, where you pitted it, all of that. It's not a crash that you're investigating. It's a law enforcement action. So what we're running into across the country, and Louisiana is like the pilot state, we're pushing this thing, is that I think state law enforcement should be able to buy commercially available technology and use it to protect the citizenry of their state. And so I ask
have
for
qualified
your
immunity.
input on that.
And they should have qualified immunity, so it doesn't go back on them when they are interjecting a credible threat.
Good point.
And, even some sort of limited federalization for local law enforcement officers to help with apprehension and even deportations to carry out these orders to prevent lawsuits from taking place from our officers. I think that there should be something there as well, and that goes hand in hand with that coordination with ICE.
So focus on drones.
Yeah, well, the gentleman yield for just a second.
Yes, yield.
When you talk about the federal laws that are being misinterpreted, are you referring to FAA laws or what?
Yes, sir, FAA.
okay.
So under the
So-
Biden administration, they sort of seized control and stopped this action, and they forced interpretations of the law, giving the authority as if we were violating FAA law.
Just, there are some ways to skirt that, I mean, that we could invoke. I mean, so we have 287G program. So that means that the local law enforcement gets trained, and then they're effectively deputized to enact and enforce INA. So you actually could do something similar to that if you wanted to.
So
get on that.
as a course of conversation there, is that we have been presented with those options, but I hesitate to embrace
Yeah.
pushing those options because I believe it's a 10th Amendment right of the state that is not, so in the existing law does authorize the Secret Service and DHS and the Coast Guard to use this particular technology both defensively to track and offensively to seize control of criminal drones. But nowhere in any of those laws does it prohibit the sovereign state from having that same authority. So I would argue that the 10th Amendment automatically empowers the sovereign state's law enforcement infrastructure to use existing commercially available technologies to deploy in the field and protect the citizenry. I yield.
Yeah, you may be right. I'm not going to say that you're wrong. I'm just going to suggest that ultimately the reason that states need to get deputized under the INA is because there is the Supreme Court has interpreted the Constitution to say if the federal government has occupied the field, which they have ostensibly, even though they didn't do it so well over the last 4 years, of immigration, then that means that the states could not actually enforce the federal law without some other authority granted. So that's why 287G is.
So how would the state respond to, how would a state law enforcement officer or county law enforcement officer respond to an identified threat legally? If that criminal threat is a drone, what I'm telling you is right now, they have the technology to identify a criminal drone, and it's incoming into something that's not federally protected, like a festival or something. And that officer identifies that drone,
Yeah.
but doesn't have the authority to seize it.
So I'm going to just suggest that you're on the right path. I think we need to do something, because I'm thinking of Langley, and we had all the drones around there.
Oh, yeah.
And even our military was like, we don't know what we can do. Can we shoot them down? Can we track them? Can we take command and control? Which they could do all of those things. But they said, we are uncertain as to what we can do.
And we need to clarify.
It needs to be clarified, and that
And
comes to this
and-
body.
And Colonel Hodges can help